In this lecture, we would like to discuss about another piece of financial legislation, in particularly relating to those financial offenses relating to property acquisition and holding and ownership of property, and that is Benami Transaction Prohibition Amendment Prohibition Act of 1988. Also will discuss about the Benami Transaction Prohibition Amendment Act of 2016. But exactly you want to start and begin our lecture from an outstanding landmark latest judgment of the Supreme Court in the leading case Union of India and another versus Ganapati Dilkam, decided in the month of October in 2024. The Supreme Court in this particular leading case, Union of India and another versus Ganpati Dilkam, 2024, recalled its 2022 judgment that struck down provisions of Benami Transaction Prohibition Act relating to. The court also agreed with the center's admission that the validity of the two provisions were not under challenge. So also the court referred the case for fresh adjudication before a bench nominated by the then Chief Justice of India, Justice D.Y. Chandrachud. And as exactly we would like to refer the 2022 judgment, which had held section 3 subsection 2 of the unamended Benami Transaction Prohibition Act of 1988 to be unconstitutional. It also invalidated all the prosecutions carried out under the Act before its amendment in 2016. So, also it declared the provisions and amendments made in the Benami property law unconstitutional and manifestly arbitrary. The court noted that the 2022 decision was made without addressing any direct constitutional challenge to the provisions of the Benami Transaction Prohibition Act of 2016. So, exactly what Benami property means? It is a kind of practice where the person who finances the purchase of a property is the real owner, but the property is held in the name of another person. This practice is often used to obscure the identity of the true owner, avoid legal obligations such as taxes, and to hold back money and promote tax evasion. So, in that connection, would like to discuss the very provisions of the Benami Transaction Prohibition Act of 1988. So, in that connection, would like to go the very provisions relating to Benami Transaction Prohibition Act of 1998. So, in that connection, we would like to discuss an example to clarify our viewpoint in regards to what exactly Benami transaction means, and in that connection, we would like to discuss one example. Suppose a property is purchased and registered in the name of Ashok. However, it is Mr. Vikas who actually pays for the same. So here, Ashok only agrees to hold the property for Vikas. This makes Vikas the beneficial owner of the property, and such type of transaction is otherwise called Benami transaction of a property. And in regard to that, we would like to discuss what exactly the very provisions of Benami Transaction Prohibition Act 1988. So, in particularly, the very act, as we have seen, the government of India had taken many steps to control and to end those which are dealing with black money, and that also through different measures. That government provided many such enactment regarding income disclosure scheme or demonetization, etc. So exactly what does Benami really means? So Benami exactly means there is no name, or without the name, a transaction of a property where a person's own name is not used but the name of another person, or a fictitious person is used instead, as already that we have discussed in our example. So the original law relating to Benami transaction was laid down in the Benami Transaction Prohibition Act 1988, and that act only consisted 8 sections. But when it was amended in 2016 as Benami Transaction Prohibition Amendment Act, then the very sections were raised to almost 72 sections. So, exactly which kinds of property would be considered as Benami property? So, any property, whether it is movable or immovable, either it may be tangible or intangible, and that property must be a subject matter of Benami transaction, then such property would be considered as Benami property. This should also include the consideration received from such property. Benami property would also include the right or such other document evidencing title or interest in such property of the real owner of such movable or immovable property, or tangible or intangible property. So, the very transaction is and who are the parties involved that we must analyze. So, if a property is purchased and registered in the name of another person, but the real owner is behind such kind of transaction, and the person on whose name it is purchased and registered, he agrees to hold the property on behalf of the real owner of the property, as because the real benefit or interest out of the property would go to the real owner, not to the person who purchased and in whose name it is registered. So, in a Benami transaction, a property is transferred held by one person, and such person would be considered as Benamidar, and the consideration for such property is paid by another person who is the real owner of the property, who derived all benefits and would be considered as the beneficial owner, and for whose benefit or interest such property is held by another. So now we'll discuss certain transactions which fall under the definition of Benami transaction. So in that regard, when a property related transaction is carried out under a fictitious name, the Benamidar can also be a fictitious person, and also where the owner of the property has no knowledge or denies having any knowledge of the ownership of such property, then it would be considered as Benami transaction. So also, where the person providing the consideration is difficult to trace or untraceable or fictitious, then the identity of the beneficial owner may also be unknown. And in such cases, if there is any transaction of property, then it would be considered as Benami transaction. So, there are certain instances of Benami transaction. So, in that case, we would like to discuss. Every state has a certain limit on the amount of agricultural land that an individual or his family can hold. As for example, in case of Odisha, in particularly the Odisha Land Reforms Act 1960 and the Consolidation of Holding and Prevention of Fragmentation Act of 1972 and also the State Abolition Act of 1951 clearly laid down that there would be certain limit on the amount of agricultural land that an individual or his family can hold. So, in particularly, if you will make a critical analysis of the Odisha Land Reforms Act or the Consolidation, Holding and Prevention of Fragmentation Act, a family at maximum could hold 18 acres of agricultural land if that particular family is consisting of 9 members, and in case of an individual, he could individually hold 2 acres of agricultural land. So, thus, where such limit is reached, people try to purchase the property in the name of another person and provide the consideration for the said property as they are purchasing the same land or property in another's name and registering also in another's name. and such kind of transaction would be considered as Benami transaction. So also, when a person who has access to price sensitive information of a company as a result of being in a position of power within the company would not be allowed to trade in the shares of the company since it would amount to insider trading. Therefore, to find a way out of this, they involve a third, unrelated party and give him the funds to trade on their behalf. So, it is in very simple way that we could analyze. Suppose the shares of a particular company, let it be the Reliance Industries, and one of the directors or any of a powerful executive member of the bodies of controlling and governing the Reliance Industries, and if he is trying to purchase certain shares in another names by the knowledge that the shares would rise to optimum limit in the stock market. So, by purchasing such share in another's name who is unrelated to the business, and that would be considered as involvement of a third party by the person who is an party or a powerful member of the inner circle of the Reliance industry, then it would be considered as Benami transaction. So that we have experienced in another case during demonetization in 2015 and 16. There were many instances of persons depositing old notes into their bank accounts which belong to another person and then exchanging them for new notes. And that almost every day happened. Once Prime Minister Narendra Modi in the midnight announced the very effectiveness of the demonetization policy. So, many persons having demonetization currencies such as 1000 rupees and also having 500 rupees notes, they immediately deposited such notes into the bank accounts of other persons, and later on they exchanged them for new currency notes. And such kind of transactions should be considered as intangible or immovable property Benami transaction. So the definition of property under the Benami Act is very wide as it also includes cash which are intangible, and such a transaction would also be termed as a Benami transaction. And now we will discuss the penalties and punishments as provided under the Benami Transaction Prohibition Act. So, one of the first penalty or punishment would be confiscation of Benami property. So once it is traced that this particular property, either movable or immovable or tangible or intangible, is a subject matter of Benami transaction under the Benami Transaction Prohibition Act Amendment of 2016, then such property which is the subject matter of Benami transaction would be confiscated, and also where a Benami transaction has been entered into the purpose to defeat the very provisions of any other law operating or in force in India, or if it avoids payment of statutory dues such as the government revenues or tax, which could include both direct or indirect taxes, or avoiding payment to creditors. Any person who enters or abets or induces another person to enter into such a transaction would be punishable, as it would be considered as Benami transaction under the Benami Transaction Prohibition Amendment Act of 2016, and such person would be imprisoned either for a period of 1 year, it may extend to 7 years, and also a fine could be imposed of 25% of the fair market of the value of such property, which is the very subject matter of Benami transaction. Either it may be movable, immovable, or may be tangible or intangible. And also where a person who is required to provide information under this particular act, Benami Transaction Prohibition Amendment Act 2016, if such person involved in Benami transaction provides false information, then he shall be punishable with imprisonment between 6 months to 5 years. So the very minimum punishment is 6 months, and it could be extended up to 5 years. And also a fine could be imposed on such person providing false information in regards to Benami transaction, and that fine could be up to 10% of the fair market value of the property. So, these are the essentials of the Benami Transaction Prohibition Amendment Act of 2016. And what exactly Benami transaction means, and also what are the very subject matter of Benami transaction, and how it was prohibited in the predecessor act, that is the Benami Transaction Prohibition Act 1988, and subsequently as it was amended in 2016 as Benami Transaction Prohibition Amendment Act, that we have discussed. And so we have started our lecture from the very latest judgment that was delivered on 18th October 2024 by the Supreme Court in the leading case Union of India and another versus Ganapati Dilkam 2024, where the apex court clearly discussed the very judgment of the court delivered in 2022. So, we have completed The Benami Transaction Prohibition Act 1988, which was substantially amended in 2016, and also the latest Supreme Court judgment delivered on 18th October 2024 in regards to a decision of 2022